said, we appreciate your support on this. We're really getting hit over the number of years. We're seeing an increase in people utilizing our forests. Partly they are free, and we think that's. We don't mind folks coming out, but we need help keeping the restrooms clean, sanitary, and other safety factors, environmental issues corrected. And with me today is Russ Henley, Assistant Deputy Director for Resource Protection and Improvement, if you have any technical questions.
Any technical questions by members of the committee? Is this just on, this will be, is it a pilot program on one of the forests, or is it relevant to all 8 demonstration forests?
It will apply to all campgrounds
and you have about 40,000 campers a year now using
Right, and
it.
it's not mandatory either. It's flexible, the fee. Yeah.
The fee is, so it will be.
Meaning that the department could, as revenues increase, lower the fees and choose to to fund go back to funding the campgrounds in other ways, but it's essentially granting authority.
How do you how would you set the fee to be reasonable? Is state parks?
I guess I'll ask the department to answer that.
Well, our recreational facilities, our campgrounds in particular, are more rustic than the kinds of facilities parks and other government agencies provide. So we would be setting them fairly low, probably in the range of $10 to $15 per vehicle or tent night. Similarly low fees for group recreation activities. And so they would be fairly modest, and again, they would be used directly to support the recreation.
Still considerably less than state parks.
Yes.
For example.
Senator Cogdell, you had a question.
Yes, thank you. Question I have is relates to the sensitivity of this policy. Have you done any analysis to determine what the impacts would be on lower-income families that I know make up a large portion of the population that utilize these campgrounds, and how it would impact their ability to continue to do that or their willingness to?
We haven't done any specific analysis, but much of our utilization of these facilities is by more local people whose travel costs for getting there are relatively low, and the rates would be very modest, and we don't believe it would cause a significant economic hardship on people, and it would help to improve the condition and maintenance of the facility, so they would get a better recreational experience out of it.
As it relates to the establishment of this fee and the periodic review of it and adjustments made to it, that kind of thing, there isn't any additional legislative oversight in that process. It'd strictly be CDF making these determinations.
There's nothing specific to oversight in the bill. Certainly we will review things from time to time and make adjustments as appropriate.
Thank you.
We may want to, Senator Cogdell, through the budget process in our sub 2, some kind of oversight or review of the fee and its unintended consequences if it's actually making it difficult for people to enjoy and use the forest. I understand what you're saying. Other people testifying in support. We've had 2 speakers, name and identification and support.
Michael Endicott for Sierra Club California, and strong support.
Thank you very much. Any other people wishing to testify in support of the measure? How about opposition? Seeing and hearing none. Again, opening it up to members' questions or comments or motions. Senator Wilk has moved the bill. With any questions or comments relating to some of the concerns that have been raised? All right. Roll call.
Senators Pavley?
Aye.
Pavley, aye. Cogdell? No. Cogdell, no. Hollingsworth? Huff? Kehoe? Aye. Kehoe, aye. Lowenthal?
Aye.
Lowenthal, aye. Padilla?
Aye.
Padilla, aye. Simonian? Wilk?
Aye.
Wilk, aye.
Yes, 5 votes. That's enough. Okay. You do have 5 votes. That bill is passed 5-2. And let's go on to the next item. Thank you very much. File item 8, Assembly Bill 2664. It's on public land, State Lands Commission. Problems with violations.
Madam Chair, members, the State Lands Commission often has to enter into costly litigation to combat persons or entities building structures on state land without proper permits or out of compliance with their permits. The Commission's only form of recourse under current law is to sue the perpetrator. Many of these structures actually impede public access to state land. Examples would include building fences into lakes and even across state parks. This bill would allow the State Lands Commission to charge administrative penalties similar to other states such as New York, Oregon, Texas, and Washington. The penalty is to be no more than $1,000 a day or no more than 60% higher than the fair market rent for the land for each day permit is violated. There are safeguards included within the bill that will allow for a hearing within 30 days of printed notice and a 6-month period of amnesty to allow the perpetrators to apply for a lease without being penalized. Basically, an attempt to achieve compliance as opposed to enforcement. I mean, that would be the first choice, would be to get the property owner to comply, or not, or the person who provided the encroachment. This bill is sponsored by the State Lands Commission, and I would respectfully ask for your support today.
And a witness with you to testify in favor of the bill?
Good morning, Mr. Chair and committee members. My name is Mario DiBernardo. I'm here on behalf of the California State Lands Commission, sponsoring the bill. The State Lands Commission generates revenue off of leases on state lands, and this revenue goes into the general fund. Frequently, we have people who use or build structures on state lands without proper lease, and therefore deprives the state of general fund money. And as Assemblyman Chesbro stated, the deterrence is really only trespass action in court to either remove the structure or to collect back rent. And looking back at our trespass cases in the last 10 years, we had 8 cases that have cost the state more than $600,000 to litigate. This bill would create a deterrent, which, excuse me, and it would save the state money by cutting out the Attorney General from the enforcement equation. And we already have an administrative process in place to actually authorize litigation, and basically that process would absorb this bill, and instead of authorizing litigation, the Commission would take action, final order. Thank you.
Thank you. Other people?
Michael Endicott, Sierra Club, California, lucky into the second seat, but I'll try to be quick. It's important, though, also to note that the State Lands Commission performs a very valuable task in protecting our public trust, the trust for all of the people of California. And at the same time, we do have a budget crisis. The budget committees are wrestling very hard with Attorney General representation. This is a fair but much more efficient way of getting started and encouraging people to comply with whatever they're doing to trespass on our state lands. So we strongly support this measure. Thank you very much.
Thank you. Is there anyone here wishing to testify in opposition? I had a question for the gentleman from the State Lands Commission. Just walk me through, someone notices or calls in a violation.
Normally what happens is that the state gets a call from a neighbor or a citizen that is getting, say, blocked access to a public area. And so staff goes through a process where we contact the trespasser and we try to work out either removing the structure that is obstructing the public or is violating the public trust doctrine or law, or to get them under lease. And normally we are successful at that. However, there are a few cases. For example, there is a sunken boat, a vessel in the Sacramento River, the Spirit of Sacramento, where we've had extreme difficulty in getting the owner of that boat to move the boat into an area where it could be disposed or properly moored and under lease with the State Lands Commission or the appropriate marina. And we've been in litigation for 2 or 3 years with that person simply to get this boat removed, which has actually caused personal injury to one young teenager who went on the boat and fell through the floor and broke his leg. So it could subject the state to liability having these unauthorized structures on there. If we get to the point where the person is not is not willing to go under lease or remedy the situation, we take the action under a closed session item to the commission, explain what's going on, explain the law, get authorization to go to court, and then through the court process, we continue to update the commission through closed session on what's going on. Staff is deposed. Discovery takes place, and hopefully we, more often than not, we reach a settlement or judgment in our favor in most cases. that's basically the process.
And the Attorney General serves.
The Attorney General, right, and the Attorney General quantifies their costs at the point where the litigation is filed. They send us statements showing how much time they're spending on the case, and they actually quantify their time in dollars by charging, I think, $170-something per hour, and that's where I've come up with a figure of approximately, over $600,000 now with these 8 cases in the last 10 years.
Out of how many cases? I mean,
Yeah, and that figure doesn't include pre-litigation work by the Attorney Generals, nor does it include staff's time, and staff spends, both the land management and legal staff at State Lands Commission spends a considerable amount of time preparing the closed session items, working with the individual.
the violation is noticed, and it's 30 days, and then there's a hearing, and within that period of time.
And our general practice is that there would be a lot more work before that 30-day notice occurred. We would definitely try to work. I mean, we have commissioners that are public officials, and I think they would rather be cooperative with the public in working on these violations rather than exercise some strong, hand over these people and not work with them before noticing them.
Thank you for that explanation. Members, other questions? Senator Cogdill.
Thank you. Number one, the example that you gave relating to the vessel, we don't read the law that way, that it would involve that type of property, but that's your understanding that it would?
Well, it's anecdotal in terms of the legal process and how we try to get someone to conform with the law. The sunken boat is a situation. You're right in that the bill does not specify boats, and it's not our intent for it to specify boats. However, this boat is almost a fixture in the river because it's sunk to the bottom, and it's been pumped out a couple of times. But we may be able to apply it to that situation. I want to be clear, though, that this is not applying to other vessels.
Okay. The other issue with that, we approved a bill last year, SB 459, by Senator Wolk, that dealt with abandoned vessels and was much narrower, I think, in scope than this law, and the governor vetoed it. So my question is, are you working with the administration on this bill, and what kind of signals are you getting from them?
I would say the difference between that bill and this bill is that bill dealt with abandoned vessels mostly. And abandoned vessels, the governor's veto's message referenced hidden costs that would be associated with that problem. We thought we could absorb it. We thought we could get salvers to remove the boats at no cost to the state, and we actually have information to back that up. In this case, we're dealing with people that actually have title to the structure, and so we have someone to work with. We have someone to pay for the removal if we ultimately decide that the structure is not there legally. And so the hidden cost issue is not. We actually view this as cost savings because you don't have litigation, and then you have someone that would be liable for the removal.
So as it relates to the process itself, and kind of a follow-up on Senator Pavley's question, is there a title search that's done, a survey that's conducted as it relates to disputes between the property owner and the state as to whether or not they are actually on state land, and how is that decided? And
right, that would.
I'm trying to understand how.
So how do you
this is the kind of thing that seems to be very appropriate, as expensive as it is, to due process, rather than for one side or the other to be able to be given the power to say, no, here's our determination, get it off, and it's $1,000 a day if you don't, type of thing. So that's my concern with it.
Right, and that's something I omitted from my explanation. When we're contacted about a violation, we have our own title unit in our office that has all the historical documents you can imagine to determine whether or not this structure is actually on state lands. And one other situation that we're talking about is when someone, say, has a recreational. I'm actually a lawyer, and I'm working on this one case where there's this recreational pier. It's not a personal recreational pier. It's adjacent to a commercial restaurant on the upland. And they've decided not to have a commercial lease. They want a recreational lease, presenting to the commission that they're not going to use this pier for commercial purposes. And they have actively told us that and concealed information that proves that they've used this pier for commercial purposes, such as weddings and filming. And what's happened is that they've been able to get away paying a recreational pier lease instead of a commercial lease. And so in those situations, we have a lease. We already know that the structure is on state lands. It's an unauthorized use of the structure. And rather than take this action against them to collect back rent, commercial back rent, which is only subject to a couple of years of back rent because of statute of limitations, we have this, they could pay 60% more than the fair market value or $1,000 a day, and we think that that would be enough to get them to enter into a commercial lease.
All right, one other quick question. Do you have any statistics that you can share with this committee relating to your track record on the litigation?
I went back and looked at our files with cases that I believe would apply to this bill, and there were 10 cases, 2 of which are pending, and we have been successful either through a judgment or through a settlement in every one of those cases, and for that case in Malibu that I just referenced, we are actually going to, at our June 28th commission meeting, resolve that through a settlement and a lease, a commercial lease.
How many of them are settlements versus judgments? Do you know?
I don't have that off the top of my head.
Paradise Cove?
Yes. and I should say that when the settlement occurs, it's usually after discovery depositions already have occurred, and the person realizes that the law is not in their favor, and I mean that's just the fact of how these cases are resolved.
Thank you.
Senator Huff.
I think this measure is a little too broad. It may be tailored for your specific instance that you're talking about, but we also have multiple cases before the courts which involving occupied homes, dwellings, and I'm concerned about the due process that they would get. The same organization that cites them is the same organization that hears their case. So it's not like in the courts where they have a theoretically independent, judicial system weighing the merits of it. So it's more like a kangaroo court, I think. Do you have any comments on that?
Well, I'd have to know specifically what kind of cases you're referring to.
Home dwellings.
Well, it's established law that public trust lands cannot be used for residential purposes, and so. We've had cases where people have built their houses over a seawall and onto state lands, and we've won those cases. And so, while that may in fact be the case where people are doing that, that's the purpose. That's one of the purposes of this bill, is to prevent people from building their house over waters, which could, affect navigation or affect public access to the waterway in some way or another. And so, without knowing the specifics of what you're referring to, I would just say that it's the intent for this bill to affect those type of cases, and that more often than not, we're successful in those cases.
Well, it's the or not that I'm concerned about, and just I think the due process in it. So.
Well, and as any other administrative, as is the case with most administrative action, it could be appealed to the court if there is a decision that is arbitrary or there isn't a sufficient administrative record, et cetera.
So it's appealable.
Right.
Let's throw the burden back on the homeowner to take that initiative. I just think the due process is a little screwed up from our normal way when it involves somebody's dwelling, whether or not they knowingly put it, hanging over state lands. I don't know. I think the courts is the appropriate way to do that. I support the bill that was vetoed last year. I think that's a reasonable approach to at least the abandoned vehicles, but this isn't even talking about abandoned homes or anything. It's just, hey, you're over here, we're going to throw our kangaroo court, and if you don't like that, then you can appeal to the courts. So,
Madam Chair?
I don't know.
Madam Chair, I do think that we have the backup of the judicial system to create a check on any excesses by the state agency, by the commission, the State Lands Commission in this case, so that it is a balance between trying to save money and be efficient on the one hand, and on the other hand, ultimately provide the due process if people are dissatisfied with and don't feel that they've been dealt with legally.
Well, normally in the courts, you're innocent until proven guilty. In this case, you're guilty, and then you're appealing it, correct?
I'm not so sure guilt is not really the right word.
Well, sure it is, because a person is cited. They have a right to a hearing. The same organization that cited them now does the hearing, and that's final unless they appeal it. So they have, in fact, been found guilty of violating the law under this that we would create, and their only recourse is to go to court where they were seen as guilty, filing an appeal, making their case.
I would just add that I was very sensitive to those sorts of issues when researching this from the get-go, and I consulted with similar land offices and commissions in Texas, Washington, and Oregon, and this bill is modeled almost exactly the same as those offices have modeled their systems, and they have all explained that to me that their system has been efficient in terms of creating this deterrence against trespass on state lands. And I mean, they have the same system where the same organization that is citing is also taking administrative action, and they're able to operate without much problem, from my understanding.
And I would like to add, Madam Chair, and I'm not sure this will
We're
satisfy
going to
Mr.
have a close to in a
Okay,
few
but
minutes.
I'm not sure this will satisfy Mr. Huff's concern, but we have numerous other state agencies who have finding authority, Air Board, Water Board, others.
We used to hang horse thieves. That was very effective also, incidentally.
But it's tiny. It was like they were split in $2,500 or something.
Senator Keel, you had a question?
A comment, if I may?
Yes, comment.
Just that these issues, especially with homeowners, are always complicated, sometimes emotional. The discussion from Senator Huff reminds me of some of the hearings that we had at the Coastal Commission years ago when I was a coastal commissioner. But as sympathetic as I am to homeowners with retaining walls and sometimes it's all they've got, is their house. I think that we have to do our very best to protect public lands. It seems to me that state lands and tidelands are an important public trust in California, and the agencies are consistently, understaffed and not adequate resources. Time does go by sometimes. Homeowners maybe not aware of boundaries and things like that. But in the end, in the final analysis, it is your job to maintain the public lands of California, and an encroachment by an individual can outweigh the public benefit of maintaining these lands as they have been defined, designated where the boundaries are. It's important work, so I think the bill's important, and I don't know if we have a motion yet, but I'm happy to move it when you want a motion.
All right, let's hear from Senator Wilk first.
Thank you. I'd like to add my support to the bill. I did author the bill last year that had to do with abandoned vessels, and it was sadly, it was sponsored by the Lands Commission, and sadly, it had bipartisan support and no opposition, and was vetoed. I think, in addition to what Senator Kehoe says about the importance of protecting public lands, I think on a practical basis, lands is very limited in terms of how they can deal with this problem now. They have to go to the Attorney General. It's extremely expensive, very difficult to enforce the law. It can be done. It costs a tremendous amount of money. So the spirit of my bill, which was to find an administrative remedy, I think is exactly what you're trying to do, and I support that. It's also important to create a deterrent. Right now, there's no deterrent. Everybody knows how long it takes you. You're not, it's just very difficult to do. So most people who are violating this will just continue on their merry way, and these are our public lands. So the importance of a deterrent and of being able to take more rapid action, I think, is a good thing to do. So given our budget situation, I think anything we can do to make it, to set up an administrative process that is more streamlined and easy is a good thing to do. People's rights are protected by our system, even if we move to an administrative process. So I would urge and I vote.
Senator Keel, you wanted to move the bill?
Sure.
All right. Any other comments by members? Senator Lowenthal?
Yeah. I too am supportive of the bill, but I am sensitive to some of the issues that Senator Huff has raised and about the protections and whether, the same agency that is citing, and I don't have a problem with that, but I do have a problem. Well, it's not really a problem. I would, if this bill goes forward and is signed as the state, I was concerned. First of all, where do the State Lands Commission hold their hearings?
We hold them all over the state of California.
Well, that's both a plus and a minus. It's a plus in the sense that it gives a chance to have everyone have an opportunity to see the state lands. It does say, I believe, in the bill that if a hearing is noticed and a person misses that hearing, there may not be another hearing. And I think that's legitimate, but I am concerned when a hearing is held in Los Angeles for someone in the northern part of the state that it makes it very, very difficult. And so as this plays out, I am concerned that we make it, and that will be developed by the State Lands Commission. And since if a person does miss it, they do not have to hold another hearing. They can just go into the administrative remedy. I am concerned about, as the regulations are developed about that we take into account to make it as easy as possible on people, because there are some real concerns about or issues about being able to participate in those hearings.
Well, I would say that we make it a point that when we hear a matter that involves geographic location, for example, the PXP lease, we held that meeting in Santa Barbara. And I am very sensitive to what you're saying.
I am too.
And I would be more than happy to work with the author in your office. Maybe we could throw something in there that...
Right. I just want to make sure. I'm not saying I have language, but I do want to make sure that as we move towards an administrative hearing process, that we protect the rights of the individual.
All right. Would you like to close, Senator Chair?
Yes, thank you.
Sorry. Before you do.
I just had a quick question as it relates to the involvement or lack thereof of the municipalities involved in this, whether it's the counties or cities or what have you. And I'm trying to figure out if they don't have their own administrative remedies that could be employed as it relates to encroachments or buildings that are, built without proper permits or what have you. Does that play into this at all?
Well, just to be honest, I have not looked at local ordinances around the state to see what kind of administrative remedies they have. I do know, though, that when we do take these actions against the trespassers, it's always an action and trespass that the commission is taking to enforce state trespass law and not necessarily local. The complaints that I've read, they're not citing local ordinances. And for the most part,
city land.
I mean, we're dealing with state law here and public trust law.
I'm just wondering, do the county assessors know where this property is? Are they, issuing a fee title tax bill on a secured roll, or?
I would have to look into that. I'm not.
It seems to me there's a remedy right there if that's the case. Whether the state would have to have any other involvement in it. But that's why I was just wondering whether or not there's any coordination between the state and local governments on this.
I would have to look into that. I'm not aware.
Thanks.
It is clear on page 2. This relates to, any easements and leasements on state lands under your jurisdiction. It wouldn't be under a city or a county's jurisdiction. We had someone encroach into a city park in my community, and the city was directly involved. It wasn't a state lands issue, but these are state lands issues.
You have possessory interest issues all over the state.
They nest. They're not mutually exclusive.
Over inside their city limits.
Right.
I see what you're saying. Not their own land, but within their jurisdiction. Duly noted. Yes, that's correct. All right. There's been a lively debate. Senator Chesbrough, would you like to close?
Yes, I would offer to Senator Lowenthal. He mentioned the regulatory process, but if you have any thoughts between now and the next committee about how we might assure that. I come from a place that takes 5 hours to drive from San Francisco, 6 hours from Sacramento, and I'm very sensitive to the challenges that people face getting to public hearings.
That's my only concern.
Statewide boards, and so a way to encourage that would be welcome. Just very briefly, this is a attempt to give State Lands Commission a better and more efficient tool to do their job. It does have safeguards, provides for an amnesty period for a person to come into compliance and get leases or permits, and it also provides for the remedy of correction of the court system if State Lands Commission were to get heavy-handed or step over their legal boundaries. So I would urge your aye vote. Thank you.
Could I just?
Yes.
I think there are a lot of different issues that were discussed this morning. I just would urge you not to. Let's put it this way: there are procedures already in state law and regulation similar to Coastal Commission where the meetings are held up and down the entire coastline from Eureka to San Diego, and they managed to sort of sort people out. When the state lands met in San Diego a couple years ago, they heard the desalination plant in Carlsbad, which was, 17 miles away or something. So that can be worked out. What I would not want you to do is tie it down so tightly that then people could take it to the Coastal Commission or other places and said, well, they did it over there, so now you got to do it over here.
I don't want to tie the commission in knots. I certainly agree with that.
Again, the primary focus of the bill is to protect our state lands, and I think that's commendable. That's what I'd like to see you keep front and center.
Okay. Thank you very much.
Okay, there is a motion. Roll call, please. And this would be due pass to appropriations.
Senators Pavley?
Aye.
Pavley, aye. Cogdill?
No.
Cogdill, no. Hollingsworth? Huff?
No.
Huff, no. Kehoe?
Aye.
Kehoe, aye. Lowenthal?
Aye.
Lowenthal, aye. Padilla? Semidian? Wilk? Wilk, aye.
Okay, we're going to be keeping the roll open. Vote is 4-2. And last, you have a resolution, Assemblymember Chesbrough, and this one is due referred to environmental quality. So I'll have the pleasure of hearing this twice.
Thank you for allowing me to present on AJR 26. This resolution urges the United States Congress, as it contemplates how to address climate change at the national level, to create a comprehensive plan and funding for states to address climate change impacts. This is the part of worrying about climate change that doesn't address us trying to reduce the human contribution to it. It addresses the impacts and trying to be prepared for those impacts, because on the assumption and the great scientific evidence that we're past the point that it can be reversed in a way that won't generate significant economic and environmental impacts. We know that climate change is already affecting California in major ways. Sea levels have risen by as much as 7 inches over the last century along the California coast. These impacts are increasing erosion, degrading water quality, threatening fish and marine life and their food webs in ways not fully understood. Our state understands and it's been reflected in AB 32 and other legislation and laws, the importance of addressing climate change impacts today. The Natural Resources Agency, in coordination with other state agencies, has recently developed the state's first strategy to identify and prepare for these occurrences and expected climate change impacts. It's imperative to urge Congress to support state strategies to address climate change impacts and fund implementation of such strategies for the health of our natural resources and the economies of the communities that depend on them. AJR 26 highlights the need to take action in planning for the real effects of climate change impacts for health, natural resources, human communities, and the economy. I'd ask for your aye vote.
All right. And witnesses in support?
Madam Chair and members, Malva Bigelow on behalf of the Nature Conservancy, and we thank the author, and we're proud to be one of the sponsors of this joint resolution. As the Assembly member pointed out, California, in the wake of Global Warming Solutions Act, is actively planning to address climate change impacts and guard against particularly avoidable climate change impacts on our natural resources and guard against costly losses. Federal funding is needed to help the state implement this plan, and AJR 26 is an important step to ensure that such funding is available. Thank you.
Crystal Molenkamp on behalf of Audubon California, also in support. We think that federal funds are critical to help the state address costly climate change impacts, and this resolution really sends that message to Congress as it considers climate change policy proposals, some that comprehensively address climate impacts and would provide funding to states like ours, and others that would not. For this reason, we request your aye vote.
Thank you. Anyone else wishing to speak in favor of this measure? Anyone opposed? Seeing none, I'll open it up to members' questions or comments.
Move the bill.
Senator Lowenthal moves the bill. It's a resolution.
Resolution. Move the resolution.
All right.
Assembly joint resolution.
And it is double referred to environmental quality.
So I'll get a chance to hear it again.
Yes, you will. All right. Roll call.
Senators Pavley?
Aye.
Pavley, aye. Cogdill?
No.
Cogdill, no. Hollingsworth? Huff?
No.
Huff, no. Kehoe? Lowenthal?
Aye.
Lowenthal, aye. Padilla? Simidian? Wilk?
Aye.
Wilk, aye.
Thank you very much. That item has 3 votes. We're going to leave the roll open.
Thank you, Madam Chair.
Thank you very much.
Should I add on to that one that I missed?
Yes, which one was that one?
Item 6.
Item 6.
Aye, Wes.
Yes, state forest, sure. We'll reopen, I didn't close
Yeah,
it.
you closed it.
I closed it, sorry.
Love it.
Did I on the check, I thought I was leaving them all open for Senator Huff.
No, because he was here. He was not voting. He was actually sitting here. He didn't vote.
Oh.
And so
He said he was sitting here.
I was sitting here. I just came in.
And so she
Didn't understand.
Thank you.
Okay, we're going to open the roll on AJR 26. Senator Kehoe?
Aye.
Kehoe, aye. It's back on call.
Senator Simidian, most of the roll's been closed because they've passed out of committee, but we would love to have you weigh in on 2 items if possible. Always appreciated. So first is file item 8, sir, Assembly Bill 2664. It relates to State Lands Commission and violations. The current vote is 4-2.
Senator Padilla? Senator Simidian?
Aye.
Simidian, aye.
That is 5. If it's enough, if you're going to wait for me to
Yes. No, that bill has enough votes. It passes 5-2. We'll close the roll on that one. We're now on to a resolution, file item 10, AJR 26, relating to climate change, and it's dual referred to one of your favorite committees, environmental quality. Roll call, please.
Senators Padilla? Senator Simidian?
Aye.
Simidian.
We're giving it a rigorous look in committee, I feel sure.
Simidian, aye. That is enough votes, 5-2.
As you always are, sir.
That resolution passes by a vote of 5-2. That is out.
Yes, I apologize.
5-2. All items have been heard. And so with that, we'll close the roll, and thank you very much for attending.
Thank you, Madam Chair.
And our next meeting will be...
We're not coming back this afternoon, and we'll be on June 22nd.
Will be the Natural Resources Committee will be a long hearing on June 22nd. We're adjourned.